Namaskar. Welcome to my channel Journey of Constitution of India. I am Dilip Singh Advocate and this is part 2 of the right of the Article 19 Right to Freedom series. First of all, I must thank you all my viewers for overwhelming response of part 1 of this series. I would like to thank especially to Mr. A. Chandra, Senior Advocate, for giving me his valuable suggestions and to improve my video. And thank you very much, sir. Please keep guiding me in future also. And I request my friends to give me suggestions so that I can improve it for in better way. Honestly speaking, while making this video, I just want to refresh your memory, what you already know, and develop some basic concepts. I sincerely I want that information from videos should assimilate to you. Just imagine that the new ideas are coming to you at the time when you really need that, either at the time of argument or producing your something while you are writing an examinations or while you are discussing the topic with some of your friends. Surely this require that you should watch the video till end, and sometimes if it needed you repeat watching it so that better understanding can be developed. Tell me the most famous slogan given by Netaji Subhash Chandra Bose. I tell you that on 4th July 1944, speaking in a rally in Burma, Netaji Subhash Chandra Bose gave the famous slogan, "Give me blood, I'll give you freedom." Some 170 years back of this slogan, on 23rd March 1775, a similar slogan was given against the British rule at Second Verginia Conference by an American lawyer. His name was Patric Henry, and the famous slogan was "Give me liberty or give me death." His slogan revolutionized the entire persons attending the conference, and they decided in written to go against the British rule and end the colonial rule. And this slogan became the war cry. I remember him today on his opinion and his ideas on the Constitution. I quote him: "The Constitution is not an instrument for the government to restrain the people. It is an instrument for the people to restrain the government." And this is the exact purpose of the Constitution. Patrick Henry was an American lawyer and well-known political thinker. He is also remembered as a founding father of the country for his contribution against the colonial rule and his ideas on the Constitution. After independence, he served as a governor of Virginia for 2 terms. Why I quoted him here? I have quoted the word of Patrick Henry on Constitution in context of right of freedom of speech and reasonable restrictions. So the balancing of freedom and the reasonable restriction in his statement on Constitution coming out. I also would like to quote a famous case of M F Hussain versus Raj Kumar Pandey, 2008 Criminal Law Journal 1407. The case of famous painter M F Hussain. In that case, Supreme Court said, "The freedom of speech is the matrix, the indispensable condition of nearly every other form of freedom." After reading this statement, I searched the meaning of matrix in dictionary to see the context in which it is used. The meaning of matrix is the cultural, social, or political environment in which something develops. So this statement of this line of Supreme Court stands for that freedom of speech is cultural, social, and political environment in which other rights of freedom develops. But we are in a welfare society, and so there cannot be absolute freedom. So our Constitution confers right of freedom on the individual, at the same time confers right on the state to restrict that freedom in the larger interest of the society. Friends, our constitution is based on the principle of checks and balances. The preamble expresses two ideas which complement each other. First, rights of the individual which correspond to the duties of the state towards the individual. Here, the rights of individual and duties of the state. And second idea is duties of the individual towards the state which corresponds the rights of the society against the individual. So everything is given in to create a balance between the interest of individual and the society. In United States, the Bill of Rights itself does not provide any such limitations as reasonable restrictions provided in our constitution, and the restriction is to be left to the judiciary to invent its ideas and different doctrines to create the reasonable restrictions. And one of the famous doctrine which American court follows is the police doctrine of police power of the state to impose limitations on the freedom of the individual. In India, the court is also given the power to interpret the reasonable restrictions of law restricting the freedom. On seeing various judgments of Supreme Court, we find that while examining the reasonableness of restrictions, the Supreme Court imposed by any legal provisions or law, certain guidelines keep in mind, such as first, what is the directive principle on that issue? Second, there should not be any arbitrary restrictions. The interest of general public must be established in categorical term for imposing any restrictions on the individual freedom. Third, every case is to be judged on its merit with regard to the changing conditions, value of human life, social philosophy of the constitution prevailing at that particular time, and the attending circumstances. Fourth, a just balance between the restriction imposed and the social control or the social goal is to be achieved. So there must be a direct and proximate nexus between the restrictions imposed and the object to be achieved. And this was beautifully said by the Supreme Court in Dwarka Prasad versus State of UP 1954 SCR 803. It was held that restrictions must not be greater than that the mischief to be prevented. So there should be a proportionate relation between the restrictions and the freedom of the individual. The question of reasonableness, while being examined by the court, it should be examined from the angle of substantive as well as the procedural standpoints or procedural perspective. Substantive practice as well as perspective as well as procedural perspective. The procedure imposing restrictions must be just and fair. So in this context, now we move to the most important aspect of this freedom of speech, and which has always been a bone of contention between government and the judiciary. That is the freedom of press. There is no specific provision of freedom of press in our constitution, as it is given in the first amendment of the American Constitution, from where we have said that we have borrowed the concept of freedom of press and speech. In United States Bill of Rights 1787 comprises the first 10 amendment of the Constitution, and the first amendment speaks about Congress shall make no law respecting abridging the freedom of speech or the press or the right of people to assemble peacefully. So here in the first amendment of the American Constitution, specifically it is mentioned that freedom of press is mentioned. The press has no special privilege in Indian Constitution, and it is kept on the same footing as the individual citizen. Hope you remember the description and the line and the classification given by Dr. Ambedkar in drafting committee why he did not put the press word in the fundamental right. Then he said that the freedom of press is covered in the freedom of speech and expression, and whenever a person is writing, as a writer or an editor. He's expressing his own individual ideas. He's covered under the concept of freedom of speech and expression. The first important case which came before Supreme Court was Romesh Thapar versus State of Madras, AIR 1950, Supreme Court 124. This case was decided by a constitution bench of 6 judges presided by Chief Justice Kania. The judgment was delivered in 5:1 ratio. The majority judgment of Justice Kania, Justice Sastry, MC Mahajan, BK Mukherjee and Justice S.R. Das was authored by Justice Patanjali Sastry. They allowed the petition and declared the impugned law as void and invalid. Whereas a dissenting judgment was delivered by Justice Syed Fazal Ali, he found the impugned law as valid in the light of the reasons given by the court in the previous judgment of Brij Bhushan versus State, and where the issue was comprehensively dealt, and on the same reasoning he found that the law is valid, constitutionally valid, and he held that the relief sought by the petitioner cannot be granted. However, the full court unanimously held the freedom of speech and expression include freedom of propagation of ideas, and also it's ensure the freedom of circulation of the newspaper. Before we go further, I would like to mention here that in this case, the Advocate General of Madras raised a preliminary objection that the petitioner has approached directly to the Supreme Court under Article 32, whereas he should have exhausted the remedy before the High Court under Article 226-227. The full court unanimously rejected this objection on three counts for the three reasons. First, Article 32 provides a guaranteed remedy for the enforcement of a fundamental right. Second, which is equally important, that Article 32 is in itself is placed in the Part 3 of the fundamental right. It is in itself a fundamental right. Third, Supreme Court is the protector and guarantor of the fundamental rights, so a petitioner can directly approach to the Supreme Court in case of violation of his fundamental right. Now, the brief fact of the Romesh Thapar case is the petitioner in this matter was a printer, publisher, and editor of a weekly English journal, Crossroad, printed and published from Bombay. The government of Madras passed an order on 1st March 1950 under Section 9(1)(a) of the Madras Maintenance of Public Order Act 1949, which is impugned here, and imposed a ban upon the entry and circulation of the journal in the state. The court observed that the freedom of speech and of the press lay the foundation of all democratic organizations. Without free political discussion, there can be no public education. So, freedom of press is essential for the proper functioning of the government. No doubt, a freedom of such amplitude involves some risk of abuse, but the framer of constitution were conscious of this abuse, and so they provided certain grounds on which the restrictions could be given. The framer, and to understand this judgment, we need to understand the ground of restriction which were imposed by Article 19, Clause 2 in the original constitutions, which included libel, slander, defamation, contempt of court, decency or morality, security, tends to overthrow state. Here we see that there is no ground in this case in the constitution as public safety or public order, whereas that act which is impugned here has the ground of public safety and public order. Majority of the court in 5:1 ratio held that Section 9 subsection 1A of the Madras Maintenance and Public Order Act 1949 imposes restrictions for the securing public safety or public order, and these grounds are not mentioned in the grounds of restrictions under clause 2 of 19. So impugned act is void and unconstitutional. The court observed that unless a law restricting freedom of speech and expression is against the security of the state to the extent that it is to overthrow the state, such law cannot fall within the ambit of the restrictions imposed by clause 2 of article 19. Supreme Court further observed that the word sedition, which occurred in article 13 clause 2 of the draft constitution prepared by the drafting committee, was deleted before the article was finally passed as article 19(2). Deletion of the word sedition from the draft under article 13 clause 2 therefore shows that that the criticism of government exciting disaffection or bad things towards is not regarded as a justifying ground for restricting the freedom of speech and the press unless it is to undermine the security or tend to overthrow the state. The judgment resulted in the first amendment of the constitution, and article 92 appeared in the present avatar, where the new word reasonable restrictions were put in the amendment, and two another grounds were added in the article 19 clause 2. These were public order and incitement to an offense. Later on by 16th amendment 1963, another ground was added, that is friendly relations with foreign state. So if anyone is speaking something which is going against the friendly relation with foreign states, then it will come within the parameter of reasonable restrictions. The issue is how to secure individual liberty vis-a-vis social interest. We need to see from different angles. Let me share my view. Genuine respect for law can spring from the understanding of the two purposes of the law. Our understanding expresses our notions of right or wrong, just or unjust, or in other words, our dharma. European jurists have also used this term by the different names like just, droit, wretch to signify what is called in our society as dharma. Our ancient concept of law embraces in the fold of principle of virtue. Montesquieu, the renowned French judge and political thinker, called it the spirits in his Esprit des Lois, the spirit of laws, these virtues, which signifies dharma in our case. Let me add here that Esprit des Lois is a treatise on political theory and pioneer work in the comparative law, published in 1748 by Montesquieu, the French thinker. Let me tell you about Montesquieu. He was a French judge, a great political thinker, and he is famous for the theory of separation of power, which thereafter came into the government functioning, that the powers are separated into different wings. We can conclude this discussion today by saying that the freedom of speech is mother of all other liberties. It is a stepping stone of human development and flourishing of democracy. So if we sum up the entire discussion in today's videos, that we referred Netaji Subhash Chandra Bose, Patric Henry, his slogan and concept of constitution, Supreme Court guidelines on reasonable restrictions, Supreme Court judgments in Romesh Thapar Case, and Montesquieu, French philosopher, and First Amendment of American Constitution. I'm summing up it because it will help you in refreshing. Now let me ask you, what are the ideas coming to your mind after watching this video? Whatever it comes to, please let me know about today's video by making comments or sending me email. so that I can understand how to improve further so that it can benefit you. In my next video, I'll discuss about the freedom, right to freedom, and the various judgments, important judgments. Thanks for watching this video. Please do not miss next video, and to get that video at time of upload, please subscribe to my channel. Thank you very much. Namaskar.